President.
The Leader of the Opposition.
Mr Deputy President, I lead for the Opposition in debate on the Terrorism High Risk Offenders Bill 2017. The Opposition does not oppose the bill. Our view of the bill is contrary to the Government's rhetoric. The Attorney-General has admitted to other audiences outside of the Parliament that most terrorist offenders will already be subject to the currently existing post-sentence detention and supervision scheme. To put it simply, the current scheme applies to high-risk violent offenders. Given that by definition terrorists use or threaten violence, it's pretty obvious why they would be covered by the current regime. To most people, it's hard to pursue an argument that terrorist offenders are not associated with the violence. We concede that there are gaps in the present structure, but they are not as wide or important as government rhetoric would suggest. It's perhaps for that reason that when the government was talking up the legislation, the Corrective Services Commissioner, Peter Severin, could not identify anyone to whom it might apply. Bearing in mind it can apply only to people imprisoned previously, if there were any, you would expect the Corrective Services Commissioner would know. Interestingly, security authorities would probably prefer to rely on the existing regime, which has a maximum detention and supervision period of 5 years, rather than the present bill, in which the maximum period is 3 years. The primary object of the bill is to provide the Supreme Court with power to order the detention or supervision of certain offenders after they have served their sentence of imprisonment, provided the court is satisfied that the offender poses an unacceptable risk of committing serious terrorism offences if not detained or supervised. This is presented as an extension of the already existing scheme that was introduced by the previous Labor government for high-risk sex offenders and extended in 2013 by the current government to high-risk violent offenders in legislation that the Labor opposition did not oppose. I note that further amendments were made recently following a statutory review of the legislation. The bill is modelled upon the Crimes High Risk Offenders Act, which is the legislation governing the current regime. Many of the provisions of this bill are identical to that act. One option might have been to amend that act rather than establishing a completely new piece of legislation, but perhaps it's only cynical of me to note that it's probably a bigger media story if the government can say it's introducing a whole new piece of legislation to deal with this issue rather than amending and building on a previously developed foundation. Part 2 of the bill deals with the extended supervision orders and Part 3 with continuing detention orders. Applications are made to the Supreme Court. The test for the court is that it is to be satisfied to a high degree of probability that the offender poses an unacceptable risk of committing a serious terrorism offence if the order sought is not made. There are provisions for interim supervision orders and interim detention orders. There are also provisions for emergency detention orders. As with the Crimes High Risk Offenders Act, there are provisions that proceedings are in accordance with the law relating to civil proceedings, provisions concerning victims and victims' statements, appeals to the Court of Appeal and a prohibition on cost orders against offenders. Likewise, conditions are set out that can be part of an ESO, provisions for information to be sought by the Attorney-General and warnings to be given to the offender about the Act. The most complex components of the bill are contained in Part 1 in Division 1.3 entitled Key Concepts. This is a series of definitional provisions setting out who is caught by the regime of the Act. An eligible offender is someone aged 18 years or older who is serving or being supervised or detained after serving imprisonment for a New South Wales indictable offence. This means the bill does not apply in respect of Commonwealth laws. This also self-evidently excludes juveniles. The court can make orders against eligible offenders who are convicted New South Wales terrorist offenders or a convicted New South Wales underlying terrorism offender or a convicted New South Wales terrorism activity offender. The first of these broadly relates to people imprisoned under Section 310 capital J of the Crimes Act, being a member of a terrorist organisation. Mr Deputy President, there are not a lot of people in that category. I'll quote from an email dated 21 November sent to the Parliamentary Research Service from the New South Wales Bureau of Crime Statistics and Research. It states, and I quote, "According to the latest publicly available New South Wales Criminal Courts data from Boxar, ending June 2017, there have been no finalised charges under Section 310 capital J of the Crimes Act 1900 since the section's commencement." Unquote. A convicted New South Wales underlying terrorism offender is someone serving a sentence or being supervised or detained for a New South Wales indictable offence that is serious and occurred in a terrorism context. Proposed Section 9, subsection Section 2 provides a definition of serious and proposed 9.3 deals with the terrorism context. A convicted New South Wales terrorism activity offender is someone serving imprisonment or being supervised or detained for an indictable offence, and the offender has been subject to a control order or has been a member of a terrorist organisation or has made statements or engaged in conduct advocating support for engaging in any terrorist act, or is associated or otherwise affiliated with other persons or with organisations advocating support for engaging in any terrorist acts. Proposed Section 11 provides a list of indicia to assist a court in determining whether someone is a convicted New South Wales underlying terrorism offender. Some provisions in this bill are different from the Crimes High Risk Offenders legislation. Section 52 provides that a court may allow a prescribed terrorism intelligence authority to make submissions to the court if the court thinks it would assist its determination. Proposed Section 60 deals with the use of offenders' information involving terrorism intelligence. An application can be made that particular information be dealt with as terrorism intelligence. The court must take steps to maintain the confidentiality of such information, including receiving and hearing argument about it in private. The court must allow a form of access to the intelligence information. The most restrictive provision is Clause 64E, little e, which allows the party's legal representative to view but not to have a copy of the intelligence, but denies the party any form of access to that intelligence. The court has given explicit power to make orders to prohibit or restrict access to, or the disclosure of, or publication of terrorism intelligence. One interesting variance between the bill and the existing CDO and ESO regime relates to the maximum length of detention and supervision orders. Proposed Section 26(6) provides a maximum period for an ESO of 3 years. Proposed Section 41, subsection 1, provides the maximum term for a CDO of 3 years. That is in very clear contrast to the current regime. Section 10 of the Crimes High Risk Offenders Act provides a maximum period for an ESO of 5 years. Section 18 of that Act provides a maximum period for CDOs also of 5 years. The current regime has a maximum term of 5 years. The bill has maximum terms of only 3 years. This strikes us as a curious anomaly given the government's rhetoric associated with this measure. And the government, of course, has marketed this as a tough new anti-terrorism law. We can see that because one can make an application to extend existing orders, the same result can be achieved under this bill. But it does seem odd and makes the government's rhetoric seem a little hypocritical, or perhaps a little overblown, as is perhaps not entirely unknown in the world of political discourse. We asked the government, perhaps rhetorically, to explain the discrepancy between 5 years in the existing legislation and 3 years in this bill. What are the different considerations that lead this bill to having lesser maximum penalties? We would be interested to know. What makes this issue even more significant is the element involved of misleading the people of the state. The government not only said it was introducing new tough anti-terror laws, it was more specific. In the midst of the media announcement on 4 October, according to the paper of record, the Sydney Morning Herald, the Premier said explicitly that the maximum period of supervision and detention would be 5 years. Perhaps she hadn't read the legislation. The Premier is not entirely across her brief and does not know one of the primary aspects of the legislation she's apparently talking up. In our view, what is worse is that her government has sought to mislead the people of the state about what they were going to legislate. The incompetence is bad, but misleading the community is worse. While we're talking about the way the government's presented the issue to the public, I note the seriousness that it has invested in the topic. A post-sentence preventative detention scheme was first raised at the Council of Australian Governments, COAG, 2 years ago, which was clear in the communique from 11 December 2015. It was raised again at COAG on 1 April 2016. If this issue is as urgent as the government claims, it is astonishing that it has taken 2 years to develop, unless almost everyone liable to be subject to the bill is already covered under the existing schemes. Some might think that this is just as well because under the existing scheme they would be caught by the 5-year maximum rather than the 3-year maximum proposed in this bill. That is not to say there are no people who theoretically are not caught under the who are not caught under the current regime who would be caught under this bill. We note the statutory review of the Crimes High Risk Offenders Act says at page 64 that certain New South Wales offenders would come within the existing High Risk Offenders scheme, and there was a Commonwealth scheme that covers Commonwealth offences until December 2016. The report under December 2016 legislation. The report goes on to say, and I quote, "However, there may be high-risk offenders with a high risk of committing a future serious terrorist offence who would not come within either scheme. Those offenders would not meet the Commonwealth threshold of having committed a Commonwealth Terrorist Index offence. For example, if an offender is found guilty of the New South Wales offence of supply a firearm, which is used to kill a person as part of a terrorist act, this offender would not come within the New South Wales scheme and would only come within the proposed Commonwealth scheme if there were also relevant Commonwealth terrorism offences for which the offender was imprisoned," unquote. The other scenario of someone currently not caught presented by the report is someone imprisoned for a non-terrorism, non-violent offence, for example fraud, who is radicalised in prison. Currently there must be a link between the offender's previous offence and future offences. Of course that report is now quite dated. If the government thought this was an urgent issue, why is it now being dealt with on the second last day of the year? Again, I'd ask the Parliamentary Secretary to give us an insight into the government's timing. Schedule 2 to the bill deals with changes to other legislation. Schedule 2.14 amends the Privacy and Personal Information Protection Act to effectively provide exemption for ASIO and public sector agencies dealing with ASIO from various provisions of the Privacy and Personal Information Protection Act. Recommendation 12 of the Joint Commonwealth and New South Wales Review arising from the Martin Place siege deals with that, as does Recommendation 42 of the Coroner's Inquest into the deaths arising from the Lint Cafe siege. I note the Coroner's recommendation refers to the Health Records and Information Privacy Act, which interestingly is not caught within this legislation. Again, we ask the Parliamentary Secretary in his reply speech to explain why that is the case. We also note the entirely unrelated amendments dealing with the local court's capacity to deal with longer-term inmates possessing prison contraband. With those brief remarks, the opposition does not oppose the bill.